To answer your question about the warrant of habitability, I don't think it's a necessary ordinance because I do feel that the present ordinances which are on the books, which is the Urban Rehabilitation Standards Ordinance, covers the points very clearly. I was at one time the Urban Rehabilitation Coordinator for the city and helped prepare the initial draft, so I'm somewhat familiar with it. And that ordinance, I was looking over the general provisions, covers all of the things such as discharge of sewage, free from rubbish and garbage, weeds and plant growth, insect and rodent harborage, the whole gamut of things that would make a property habitable. And the city does have the authority, in my opinion, to very well solve a lot of those problems that sometimes occur.
There are a number of remedies that are presently available. One of the remedies that I pointed out actually is a state statute, Article 5236. That was a law that was enacted exactly 100 years ago, and it provides remedies for the tenant, and it also gives the tenant a lien against the landlord's property, which, as I pointed out, could be a piece of property worth hundreds of thousands of dollars in the event that the tenant has suffered damages as a result of any breach on the part of the landlord.
Don't tenants already have remedies? They can go to the courts without remedies, without another law and another bureaucratic structure in the city?
Nah, you can ask any landlord, any large landlord or any slum landlord what tenants' remedies are, and they'll tell you that if you don't like it, you can move out. You're talking just like a medieval landlord. The fact is that you contract for a home, you expect that the place will be livable and will be maintained as such. But your only remedy now is to move out and to sue the landlord for damages. This puts the burden on you.
This does require court action. It's not a self-help remedy. Most self-help remedies, as you will find, have been declared unconstitutional, and I think it would be unconstitutional in this instance as well. It's just like any other remedy. The law provides the remedy, but you must take it to the courthouse to take advantage of that remedy, because there you have a fair and impartial judge to mete out the remedy and to determine the damages.
What slum landlords do is they buy up property and then they systematically let it run down, bleeding it of the rent. You see, they don't make repairs, they don't put their money back into it for maintenance purposes. They bleed the property until they run it down. What this does is lower property values, lower surrounding property values to the point where the neighborhood gets redlined, number one, to the point where the housing stock begins to run down and gets past the point of no return to where it has to be redeveloped, you see, which leaves basically the present residents no way out. Now, under the present statutes, if a place gets so bad that the tenants have to be relocated, then the taxpayers have to pay for the relocation costs. And I'm talking about a place that gets so bad because of the landlord's abuse or neglect, because it's a slum property owned by a slum landlord.
If the tenant finds that a piece of property that he lives in is not being maintained to the standard that he requires, he always has the right, and as I pointed it out, he can move, and if the landlord has violated some condition of the rental agreement, then he has the right to move out.
Who are some of these slum landlords in East Dallas?
Well, you've got Terry O'Brien, you've got Clyde Crum, you've got William Hooper. I can go on and on. You've got Al Lubnitz, Fred Secker, who are members of the Dallas Apartment Association. You've got a lot of big investors and big developers beginning to buy in to the area. Henry S. Miller, Laughlin, all these people. You see, this is why that the Dallas Apartment Association and the so-called reputable landlords oppose warranty of habitability, because they got their fingers in the pie.
Gee, I didn't know he included Henry Miller, because we're not involved in what he might classify as slum properties. I think that's the difficulty in this, is that responsible operators, and the majority of these folks are in business and have to do a good job with it, are responsible. They have helped formulate some of the laws, like on security deposits, that are so important. and it would seem as though we're all being tarred by the same brush for a small minority of people who do tend to exploit. You can't say that people, that there are no exploiters. There are a few, but I think it's a limited number. But this ordinance has in the past been able to eliminate many of these physical conditions which were adverse to someone living in them.